Hello and welcome to the program. I'm Shola Shieli. Former president of the Nigerian Bar Association, Olisa Agbakoba, is my guest on this episode of the program. I began the interview with his views on the whole electioneering process and the outcomes that we have seen so far.
The elections are not what I would consider credible, free, transparent, or fair. And I say this in the context of the Electoral Act that set out clear technological parameters, which even the INEC chair was mouthing and boasting. In fact, at the point he gave a press conference to say that those who say that we shall not be technologically driven in this election, it's all fake news. But it turned out that all what he said wasn't true, because the elections were absolutely bungled. You know, the deployment of the technological things that he said would happen failed. If it had worked, maybe, but that's what happened. They just said failed across Nigeria. And it failed only in respect of the presidential and not the national, assembly election. So that throws up a lot of, why did this work here and it didn't work there? I personally didn't feel good nor satisfied about the outcomes, and that's why you have petitions. It's not surprising that Alhaji Atiku, Peter Obi, and I think 2 or 3 other presidential candidates have gone to court. So we have to wait for the court to make a pronouncement as to what they think were the reasons why these petitions have been lodged.
So in your own estimation, you don't think that there was substantial compliance with the Electoral Act?
Well, you see, that question is tricky, because in the history of presidential petitions, not a single petition has been overturned. The closest was when the Supreme Court split 4-3, and I might remind you that one of the Supreme Court justices, late Pat Sachalonu, made a very profound statement in Buhari 2. Buhari had 3 petitions. He said, looking at the legal framework of Nigeria's electoral law and the number of witnesses required to be called, I doubt any presidential candidate can ever win a petition, because the bulk of evidence and the burden required to satisfy the court that you were the person who should have been declared the lawful winner is so heavy. And the time frame, in my view, is insufficient. Which is why in the Waste panel, which I was a member, we said INEC must be impartial. The big problem is INEC's culpability and also being a defendant. So in the petitions that have been filed, the key defendant will be INEC, not Tinubu or anybody else, which is wrong. The duty of INEC is to say to the court, here are the documents, and INEC withdraws. But INEC is actually an active defendant, and INEC obviously would want to show that the elections were conducted in accordance with the Constitution and the Electoral Act. That's the problem. Had the Waste recommendations been legislated, we would be in this problem. But it's in the interest of those who run elections, politicians, not to have it passed. So they've sat on it in the National Assembly. That's number one. Second thing that I now notice is that the National Assembly actually told us a lie. Even me got caught up with the misrepresentation that the National Assembly made. I thought that the representation of the National Assembly in respect of electronic voting had consequences. It has no consequence. So if you didn't use beavers, and so what? The electoral framework allows 2 parallel processes: manual, electronic. So I could hear INEC say, well, okay, it failed, and so what? It failed, but don't forget we were doing manual collation. And that manual collation is exactly what you scan onto the BVACs. So what are you talking about? So what's the difference between the manual scan and the electronic scan? Those are going to be the challenging issues that INEC will present. And INEC, in my view, will present it strongly because they see themselves as, oh, we have a duty to defend the elections we conducted. But if that burden wasn't on them, then they will tell the truth. But I don't know in any petition from the time of 1999, or not about this one, that INEC has not absolutely been dishonest. That's it. That's the problem. And I've seen in past petitions where INEC and the respondent are working together. How can you win? How are you going to win? How are you going to win?
So the body should have been on INEC to show.
As a neutral body. The court will summon INEC to say, yes, you conducted these elections, tell us what happened. But INEC is not a party. So INEC will now bring everything. There will be no burden to defend it, with their sweat and blood. There will be no burden to lie. They say, oh, yes, in this one, here's what happened, and the court can see it from a neutral witness. But if INEC is a party, it changes the picture. That's the problem.
Now that attention has shifted to the courts, the tribunal, can I ask if you're representing any of the parties in any of the petitions?
Why should I tell you that? I think that's personal to me.
When the Electoral Act was passed, it was hailed as a game changer, by some commentators. But as things turned out, and as you've also alluded to, these elections cannot be said to have ranked better than previous ones. No. So where do you think that we're getting it wrong? Is it in the laws, the people to implement the laws, or even the people on whom the laws are supposed to serve? It's
INEC. They are the ones who operate the electoral law. So, and that's the point that I'm making, that it's not so much the technology that really is the problem. It's the electoral management body. I mean, in Oasis time, when we sat, we did our best to make INEC absolutely independent. Part of what we recommended, some have been done. But INEC is still going to National Assembly begging for money, or to the president. So they're not independent. So there's a way in which you would say that INEC is not in the middle. It's not in the middle. It's always tilting in favor of the party in power. And if it does so, then you are unable to unravel the huge amounts of evidence required to overturn what INEC had done. And it doesn't help when you put in this issue of substantial compliance. What does it mean, really? I don't understand what it means. So are you going to say to me, if I show evidence that the elections have been so badly conducted, the courts then ask me, okay, how does it affect you personally? That's what the courts always say. The Supreme Court has said, show me how it affected you personally. That's a very high burden. So unless we implement the recommendations of OAS, we're not likely to see free and fair elections in a long time. INEC must be absolutely independent. We've tried the one where INEC is manual, no technology. There were problems. Okay, we've tried technology now, with BEVAS and IREV and all those acronyms. It didn't work. It failed. So what, therefore, is the problem? The other thing to say is, should INEC actually be doing all it's doing? It's not doing far too many things. It prints ballot papers. It's the referee. It just, to give you the analogy of a football match, the referee in the football match just comes with a whistle. He goes into the pitch and he regulates the football match between A and B. He's not responsible for cutting the grass, painting the field white, marking the 6 and the 12 and the 18-yard box, making sure the nets are all good. That's not his job. INEC is overburdened. And I think that the next challenge would be to say INEC's vast responsibility, security, it is Nigeria's largest printer. INEC should leave all that. Let it just put the whistle in the mouth and get its work done. So I think that's another problem. So because of the type of personnel. Yeah, I mean, you saw the collation centers. This thing was like 100 years ago, where some professor is reading something that he can barely read. This is all digitally controlled. After he's read, say, okay, how many overvoting did you have? Come on. The guys would come, from their collation centers, everything is tabulated. So we need to find people who understand logistics. A lot of what happens is logistics, and digital experts. Professor, with due respect to him, what is his qualification to be chairman of INEC? I don't know. What's his qualification? So we now have to start to think. If we want to have a good and efficient electoral management body, then we're going to ask who are best qualified. The thing should be full of digital top experts, IT people, so that they are able to even produce the results in 2 hours. If you had a vote, it's counted in the polling unit. What is the difficulty of getting the results known in 5 minutes? Because what INEC claimed was that we'll see it real time, live. If the MBA can do it, can you imagine? Let me use my time. When I ran as MBA president, we began the voting process, I think about 3 p.m. and finished the following day, because everything was manual. But once this guy introduced the digital process, I voted from Malta, and I could see the results, real time. If INEC can emulate the MBA process, that's the end of it. There'll be absolutely no complaint. So in situations where there is a failure of the network, there's an offline capture. I can scan something into my phone, but it might not go. But the results are there. And this is what I say would be the role that experts, not us, I'm not an expert, this is the role that experts can play in determining how to take the votes of one person and collate with the second person and get a national result. I don't think it's rocket science. So overall, my overall assessment of the process was that INEC absolutely bungled. Absolutely. I don't even talk about the issue about lateness. Some places they came even at 3 p.m. What do you say to that? And the problem is the logistical nightmare is beyond INEC's capacity. Pushing all those materials. You need people who understand logistics, not INEC. INEC has no skills in logistics. So those are the things I think we need to look at and hope. Because for me, 2023 elections, I think they're in the grave already.
How confident are you that our courts will do justice in these petitions?
I've lost a bit of confidence in what the courts have been doing lately. I mean, there was a time you could say, on the facts and the law, this is the likely outcome. Today you cannot, because there have been all kinds of silly decisions. The most silly was that concerning the President of the Senate, who, in order to become Nigerian president, rushed off to buy a ticket to be a presidential candidate of the APC. And that meant he did not take part in the senatorials. Lo and behold, he lost. He now ran back after the horse had bolted, clearly to anybody who has any brain, including the justices of the Supreme Court, I might add. And they said no, that the man actually should be the senatorial candidate. That is the most ridiculous decision I've ever heard that the Supreme Court had delivered. So that's why it's difficult. Of course, I don't want to talk about the case of Imo State, where everything was turned upside down. So I don't have the sort of confidence that I used to have in the judiciary. And I've not been surprised if this thing goes one way or the other. I cannot forecast the outcome. I have the legal tools and the factual issues. So if I put it into my computer, I know what answer it will give me. But I'm not part of the panel. So I don't know whether the justices will see it the way I'm seeing it. But I can tell you, from my own perspective as a lawyer of 45 years at the bar, that the answers are glaringly obvious. But as Oliver Wendell Holmes said in the Raleigh School of Jurisprudence, it is the prophecy of what the court does in fact, and nothing more pretentious, that is the law. So if you ask me, what will be the outcome of the petition? First of all, I cannot say because it's sub judice. But second of all, I cannot even say because the Supreme Court itself is unpredictable. It ought to be predictable, which is why people are now beginning to question. There's a new school of thinking coming up to say, should the Supreme Court really be final? See what they're causing now? Should they be final, or should their decisions now be subject to parliamentary review? It's an argument that is now growing in judicial circles. The confidence that is eroding for people to begin to think, what the hell, can't we do something to these people? That's what's happening. I mean, 7 men just come out, sit down on the chair and read something, and we say, okay, that governor is sacked. Why? Who are these people? It should be taken seriously. That would not have happened 20 years ago. When these men come out, you fear them when you see them come out. And when they speak without fear or favor. Is it the same thing now? I don't know.
Welcome back. The Court of Appeal, Abuja Division, on Friday upheld the election of Governor Ademola Adeleke of Osun State. Delivering judgment in the appeal filed by Adeleke on Friday, a 3-member panel of justices held that the election tribunal erred when it ruled that the first and second respondents, Boyega Oyetola and the All Progressive Congress APC, proved the allegation of overvoting. The judgment is a unanimous one by a 3-man panel led by Justice Mohammed Shuaibu. The panel faulted Oyetola and APC that they only relied on the data from the back-end server and failed to look at the voters' register, which forms the foundation of the whole electoral process, and as such cannot strengthen their allegations of overvoting. On the issue of jurisdiction, the court resolved in favor of Adeleke, saying that Section 285, subsection 8 of the Constitution as amended, the court has every right to entertain the appeal. The panel dismissed the decision of the Osun State Tribunal, which directed that a certificate of return be withdrawn from Adeleke and issued to Oyetola. Here are some reactions from that judgment.
Judgment has been delivered in respect of all the appeals. Before this Court of Appeal, they allowed all the appeals filed by the governor-elect, Senator Ademola Adeleke. He won his appeal. The PDP as a political party won its appeal. INEC as an appellant before this Court of Appeal won the appeal. So the totality of the appeal presented before the Court of Appeal herein have succeeded, and the court has affirmed that Senator Ademola Adeleke remains the governor of Osun State.
There are so many issues involved in this appeal. Some of the issues we won. A bit more of the issues we lost. Overall, we lost the appeal. But it's so interesting that we believe that as soon as we collect the various judgments, which are all more or less the same, we would study the judgment and then make our decision. But it's most likely, because of the very interesting nature of the decisions made, that the matter will not end here.
This is a case of Daniel that has come to judgment. Exactly. Of course, the judgment today manifests not only justice, but the scholastic content of the judgment is certainly going to be edifying, because certainly the legal profession is richer for the judgment delivered today. The innovative and revolutionary provisions of the Electoral Act have received judicial adjudication today by the judgment as delivered today. The innovations, or rather revolutionary innovations in the Electoral Act have received judicial determination today by the judgment delivered. Section 137 of the Electoral Act has received judicial determination today. Today, the legal profession is richer by this judgment as delivered, because it's going to be a beacon guide that will illuminate the path in the election petition tribunals that are now ongoing.
And just before we go, let's quickly do a recap of some of the top trending stories from the courtroom.
We begin with the Supreme Court's reaffirming of Mr. Edozie Njoku as the national chairman of the All Progressives Grand Alliance, APGA. The Apex Court made the pronouncement in a judgment on an application by Mr. Njoku, where he sought the regularization of the amended judgment of Justice Mary Odili delivered on May the 9th, 2022. Mr. Njoku's motion also followed a letter of the Supreme Court to him on January the 19th, where the Supreme Court had addressed him as the national chairman of APGA and advised him to approach the court by way of a motion to correct the slip. The accidental slip, which was corrected by the Supreme Court, has restored Mr. Njoku as the actual national chairman of a party that was wrongfully removed by Jigawa High Court. In a lead judgment, Justice Garba Lawal held that it was Mr. Edozie Njoku that was wrongly removed at Jigawa without being joined as a party. Justice Lawal subsequently stated that Mr. Njoku's application was meritorious and consequently granted it as prayed.
The lead judge or the judge who gave the ruling saying that Oye's name should be deleted and replaced with Chief Edozie Njoku as national chairman. It speaks for itself. I don't want to make too much noise because APGA is one. There is no, after looking at how the elections worked out, there is nobody won. The only thing is that the right thing is being done now, and I'm assuming my leadership as national chairman of the party. I was happy that people from Oye's camp came and shook me and greeted me after the judgment. It shows that APGA problems are coming to an end.
Edozie Njoku cannot be national chairman of APGA because it does not exist. He was not a party to the suit at the Court of Appeal, Kano. He was not a party at the Supreme Court. The Supreme Court threw away his application for joining that. What are we talking about in this country? My national chairmanship is not in dispute. It has been settled by the Supreme Court.
I think that was unconscionable.
Nigeria's former Deputy Senate President Ike Ekweremadu has been found guilty of organ trafficking by a UK court. Senator Ekweremadu and his wife have been convicted of bringing a 21-year-old man to the UK from Lagos to use his kidney for their daughter's surgery. The Nigerian politician, alongside his wife, Beatrice, and Dr. Obinna Obeta were also convicted of conspiring to exploit the man from Lagos for his kidney. Prosecutors told the Old Bailey that the organ was to be removed and given to the couple's daughter, Sonia, who is 25 years old. The victim, who was taken to the UK from Lagos, was meant to provide his kidney for the transplant, worth about £80,000, at the Royal Free Hospital in London. In Lagos, the Federal High Court has struck out the federal government suit seeking to recover and forfeit the sum of 70 trillion naira it alleged was stashed in 29 bank accounts by some looters. Justice Peter Lifu held that the federal government's lawyers and the private lawyers, which it subsequently gave a fiat, did not diligently prosecute the case. The judge expressed shock that the plaintiff counsel, Senior Advocate of Nigeria Mohammed Ndarani, and subsequently Senior Advocate of Nigeria Femi Falana, suddenly developed cold feet over this alleged public interest case. Delivering judgment on the substantive suit, the judge criticized the federal government for not diligently prosecuting the suit. And we round off with a report that the Federal High Court sitting in Lagos has fixed March the 30th for its ruling on various applications challenging the order restraining the Chief Executive Officer of Seplat Energy PLC, Roger Brown, from parading himself as a CEO of the company. Justice Chukwucheku Aneke fixed a date after entertaining argument from counsel to the respondent on the application seeking to vacate the ex parte order earlier granted by the court and to strike out the suit. On March the 8th, the court had restrained Roger from parading himself as a company CEO, pending the determination of a suit instituted against him and others by some aggrieved stakeholders of the company. The shareholders had in their suit filed by their lawyer, Senior Advocate of Nigeria Jeff Njikoye, accused the foreigner of racism, favoring of expatriate workers, discrimination against Nigerians, and breach of good governance. But counsel to the first respondent, Senior Advocate of Nigeria Bode Olanikpekun, opposed the application, arguing that the ex parte order granted by the court affected many other people who are not parties before the court. Counsel to the other respondents aligned themselves with Olanikpekun's submission, and they also asked the court to hear the application for setting aside the ex parte order made on March 8, 2023.
And that's the program for today. If you missed any parts of it,